while he is in custody. Now, the lawyers of course challenge that, look, the entry of nolle prosequi or termination of the criminal process at that stage was an exercise of discretion. And because it was an exercise of discretion, there was the need for the Attorney General to have rules and regulations under Article 296 Clause C regulating the exercise of that discretion. And because there was no such regulations, the Attorney General exercise of discretion in entering a nolle prosequi in the matter was unconstitutional. Doesn't it look the same as the argument of the GBA?
Yes, it's very similar.
Yes.
Yeah.
So which means that what the GBA is raising now is not new. It is something that had been raised before the Supreme Court, and the Supreme Court decided on it. And the least anyone, any member of the GBA or any leader of the GBA could have done was to go to the authorities to see what the courts have said about the claim they are making. Now, what did the Supreme Court say in this matter? The Supreme Court, by majority, now speaking through Mafusao, said that the exercise of discretionary power that is conferred on the Attorney General to enter a nolle prosequi and to terminate a criminal proceedings at a stage where the accused person almost thought that his fate would be known was an exercise of executive authority. That exercise of discretion was executive. And so it did not require rules and regulations to be laid under Article 296 Clause C governing the exercise of that discretion. Now, this is an Attorney General deciding whether or not to continue in a criminal matter that affects the rights, the liberty of someone who was in custody. The Supreme Court said, no, that discretion is in the nature of executive authority and did not require regulations under Article 296 Clause C. And they say that Article 296 Clause C does not apply to such exercise of discretionary power. And so in that case, the Supreme Court actually made a distinction between an executive exercise of discretion and judicial or quasi-judicial exercise of discretion. Now, I want us to compare. Now, if an Attorney General can enter a nolle prosequi in an exercise of discretionary power to prosecute or not to prosecute someone who is in custody and whose rights are affected, is that not supposed to be closer to judicial decision than a president suspending someone? Now, I just want us to compare. Now, the discretion of the Attorney General to enter a nolle prosequi and the discretion of the President to suspend someone, an appointee from an office, or to be specific, the discretion of the President to suspend a Chief Justice who is going through removal process under Article 146. These two exercises of discretions, which one is executive and which one is closer to being judicial or quasi-judicial? For me, these two decisions, the President suspending someone pending an investigation of a matter against the person, and the Attorney General exercising his discretion to enter a nolle prosequi, are similar in nature. But if you ask me, the President's exercise of discretion to suspend the Chief Justice is more executive in nature than the Attorney General exercise of discretion to enter a nolle prosequi. if the Supreme Court said that because the exercise of discretion is executive and that it does not require rules and regulations under Article 296 Clause C, then of course the President's discretion of suspending the Chief Justice in this process is also executive and does not require rules and regulations under Article 296. I think the GBA should have taken their time to go through this decision. But what I noticed is that they just go straight, and I believe they were influenced by certain arguments in the media and some write-ups that actually do not take consideration of the constitutional provisions and their interpretations by the Supreme Court over time. So for me, that statement is not only prejudicial, but it's also incompetent. That statement is incompetent in several regards, and it reveals that the GBA appear not to know what it is doing. It appears not to know what it's doing, because if you issue an earlier statement saying that because of tendency of issues before the courts, you will not make pronouncements, and then you subsequently issue a resolution or a statement saying that the process is unconstitutional, aren't you admitting that you are prejudicial of the matter that's pending before the Supreme Court? So for me, in a nutshell, I can only tell you that I do not agree with that statement. But what is more worrying, I think it reveals more of who is important and not what is right.
Well, quite interesting points you make. The GBA's suggestion is simple. One of the ways of resolving this is to publish the Prima Facie determination that was made by the President and the Council of State. Do you think that is grounded in law, and do you think it is become necessary due to perhaps the public discussion on the matter?
That is first. That's not grounded in law.
Well, we'll try and get him back and conclude the conversation on that. Perhaps to that last question. Then we can end that conversation and move on to maybe something else. Don't forget that today the National Apprenticeship Program is also being launched today. The Go Board will hold their maiden press conference. They've been doing quite a lot there. We also hear from the Attorney General today. The Attorney General is talking about cases that they are looking at, charging people on, and other cases they've been investigating. But I'm sure questions will come up as to what he thinks about this. His deputy has spoken largely. We haven't heard Dominic Kaine on this matter. Maybe he might not. And of course, links or lawyers in search of democracy will also be commenting on this issue. But in the meantime, we all know say free they be. And the Betika app is giving 100% free bet. All you need to do is download the app from the Google Play Store to play and win big on your favorite games the most convenient way. It's that easy. Visit www.betika.com for more, or dial *263#. Terms and conditions apply. This advert has been vetted and approved by the Gaming Commission of Ghana. Bet responsibly, not for persons below 18. Gaming can be addictive. Dede says, is the GBA crying more than the bereaved? Were the GBA leadership one way or the other compromised during their hands were in the chicken soup with the MPP? There's also John Donko who says the MPP want GERTRUDE Torkornoo to remain as the Chief Justice to shield them from their corruption. There's Buzi Bettel. Good morning, Buzi. Dede says, Senator, please ask OSMAN. Okay, I will ask him that question, but says, what are the functions of the GBA? Does each region have its own bar association? Yes, there are regional bar associations. Frank Davis used to be chairperson of the Greater Accra Regional Bar Association, as I recall. James Kwame Somwa is also joining us. Good morning, watching us live from Spain, and good morning to Fatih Mohammed, who is watching us from Saudi Arabia, Riyadh specifically. Charles Agbogan says good morning. Great work you people are doing. Our assistance of the land will protect your people. Good morning to you. Thank you very much, Charles. Victor Thompson, the GBA shouldn't insult our intelligence at all. We know they are doing all this because they want Gertrude Torkornoo back to cover their members who are caught in state looting and stealing. Don't forget the president of the GBA, Fuagate, is the wife of Joe Gatti, the railway minister, under whose watch we had the Sky Train scandal. Positive change in Medina is also joining us. No amount of noise from the GBA, the law still remains the law. Former President Kufuor used the same Article 146 to remove lawyer Charles Osei from office, but GBA said nothing. Now is the turn of a judge, and GBA says what? So lawyer Osman has just joined us on the line. Just to conclude the conversation on that question I asked lawyer. I was asking whether the proposal to publish the Prima Facie case, that was the Prima Facie determination.
No, you see, that's why I said that even that one is not grounded in law, because the Prima Facie determination is a process that is part of the proceedings under Article 146. And Article 146 itself is saying that that procedure should be confidential. So why would you find a GBA, an association no less an association than the GBA, now advocating that something the Constitution has prescribed should be done? In other words, they are calling us to be unconstitutional. In other words, they are saying the president should do what the Constitution says he shouldn't do. And this should be the GBA who is on another breath saying they are upholding the Constitution, they are upholding rule of law, and they are fairness and justice. Is this consistent? The Constitution says the whole of the procedure under Article 146 should be kept confidential until the end. Now the GBA is saying publish it so that everybody sees. Now, the other hypocritical aspect of it that I must say is that why didn't they say that about President Akufo-Addo when he decided that there was no Prima Facie case in the Kwaku Azar petition? Because that is also a Prima Facie determination. The Prima Facie determination is two ways. Either you determine that it exists or you determine that it doesn't exist. Either way, it's a decision on Prima Facie case. So if one president decided that there was no Prima Facie case, and the same GBA did not come out and say, no, you have to publish the facts and the basis on which you arrive at that decision. The GBA did not come out to say that. Why would they say that now about another president who has found Prima Facie case based on different petitions? And for me, I think the consistency is what is required, because consistency will show that you are honest, and consistency will bring confidence in the GBA. But if you are inconsistent and you pick and choose as and when you deem it right, then it is causing the GBA itself and all of us to lose confidence in the sight of the public. Yes.
And on the basis of that, Dede, I'm sure she's in the US. She sends a comment that I should read to you. Says, please ask OSMAN, what benefits at all do members of the GBA get? What does the GBA offer its members? Or it's just a prestige by joining the GBA, belonging to a so-called bourgeoisie group? How do you respond to that?
Well, I mean, it's a legitimate question a citizen must ask. So which means that even the ordinary citizen is seeing that the inconsistency of the GBA is revealing that the GBA wants something other than the general good of the people. Otherwise, this question wouldn't have been asked. You know that. The person has seen that, no, this is not a GBA who is pursuing a public interest in the matter. There must be something they gain. And this is what I am talking about, which means the confidence in the GBA is already on the decline in the sight of the public. And this decline is as a result of the inconsistency and the clear manifestation of interest in the matter one way or the other, which the GBA should not do. The GBA should have as its priority what is right, not who is important.
Thank
Yes,
you.
Zana.
Thank you, as always, for speaking to us.
Most welcome.
Lawyer ALHASSAN OSMAN, private legal practitioner. We speak to him on many constitutional issues when they arise. This morning we were speaking to him. In fact, he perhaps thought that all this were coming up. And so if you listen to our earlier conversation, he tried as much as possible to address some of these issues in case they came up. And they are brought up by the GBA, Ghana Bar Association. Many